Did you know that transferring your home with a mortgage into a trust won't trigger the lender's due on sale clause? Many homeowners are worried about foreclosure when transferring property to a trust, but federal law is on your side. By the end of this video, you'll know exactly how to transfer your house into a trust while keeping your mortgage in place legally and safely. Hi, I'm estate planning attorney Mike Smith with Smith Barid LLC, and I'm half of the estate planning guys. We've helped thousands of families secure their homes through smart estate planning. Let's make sure your home is protected. Stick around because I'll explain the one federal law that forces lenders to allow this transfer even if you still owe money on your mortgage. Most people don't realize that transferring a home into a trust can completely avoid probate, and that can save your family thousands of dollars. When a home is held in trust, it doesn't have to go through probate when you pass away. Probate is a process that occurs when someone has a will or they have no plan at all, where the probate court appoints an executor who then can wrap up the estate. Instead, with a trust, automatically transfers the home to your beneficiaries according to the terms that you set in the trust. And that avoids the costly legal fees, the long delays, and the public court involvement of the probate court. Additionally, transfers through a trust aren't public record, unlike probate proceedings. So you decide exactly who receives your home, how, and when. And the trust ensures that your family avoids legal battles, court fees, and complicated paperwork. So are you worried that your lender might demand full payment, trigger that due on sale clause if you transfer your home into a trust? Well, here's the legal protection that most people don't know about that keeps that from happening. Many homeowners believe that transferring their house into a trust will violate what's called the due on sale clause in the mortgage. And every standard mortgage contains a due on sale clause. And what it says effectively is that if you transfer your home to someone other than yourself, the lender can trigger whatever remaining balance on the mortgage is due as being due immediately. They can demand the full loan balance be paid immediately. In 1982, a federal law was passed. It's called Garn-St. Germain to protect homeowners. And this law prohibits lenders from triggering the due on sale clause when property is transferred into a trust, as long as the home is your primary residence and the trust is created for your benefit. So if we have those two key things, then the lender is prohibited from triggering that due on sale clause when you transfer your home into the trust. So let's say you have a $250,000 mortgage on your home and you want to place it in a trust. Without the Garn-St. Germain Act, your lender could demand that the entire amount be paid immediately. But since the law prevents this, your mortgage stays in place just as if nothing had happened at all. So let's talk about step by step, how do you transfer your house into a trust? Now you know that the lender can't call your loan due, so let's walk through exactly how you would transfer your home to the trust. The first thing is you have to create the trust. So I recommend working with an experienced estate planning attorney to set up your trust properly. A trust that is not properly set up can end up being a train wreck. So you don't want to, use one of these online services, that won't give you the benefit of working with an attorney that really knows what they're doing and can create a trust that's specifically for your circumstances and can ensure that the trust meets the legal requirements that are there for your state. The second thing is, you can notify the lender. It's not a requirement, but it can help avoid confusion if the lender updates their records and notices that the home has been transferred into this trust. I don't normally recommend you do that. I think it can raise questions from the lender that are not necessary. There's nothing they can do about it. So I don't usually recommend that you notify the lender, but if you want to just be cautious about it, if you're really conservative, want to make sure that the lender knows about it, you can do that. And, it's just one of those things where they can't do anything if you transfer it. And so you may end up having to go back and forth with them and explain it to them because some lenders are just not that sophisticated. The third thing is that you need to actually transfer the property into the trust. So a deed is prepared going from your name into the trust name. And Again, I think you need to use an attorney to do this to make sure that the legal description is proper and that the grantor and grantee names, the transferring parties are named properly in the trust. The grantor is the person who is transferring, the grantee will be the trust in this case. You want to make sure that's all done right. So I recommend using an attorney to do that. The next step is to file the deed. So the deed is filed with the county recorder's office. That could be the Superior Court clerk. That could be a county recorder. It varies by state. And then you pay any fees that are due to file it in that location. So FAQ moment, question, do I need to refinance my mortgage after the transfer? Answer to that is no. The mortgage stays in place just as it was thanks to the Garn-St. Germain Act. If you are finding this information helpful, if you'll hit that like button and subscribe for more estate planning tips. We put out videos once or twice a week that we give all kinds of great tips on important things about estate planning. So let's talk real quick about some common misconceptions about transferring a house. There's a lot of information out there and some of it is just not right. So let's bust some myths here. The first thing is I'll lose control of my house. That is absolutely not true. If you are the trustee of the trust, then you remain in full control and you can make all the decisions about what happens with your home. The trust exists for your benefit, allows you to live in the house, sell it, refinance it, whatever you need to do. The second thing, my lender has to approve the transfer. That's not right either. Under federal law, you don't need lender approval as long as the trust is structured properly. Number 3, this only works for paid off homes. Nothing could be further from the truth. If you have a mortgage, you can still transfer your property into a trust. This is exactly what Garn-St. Germain covers. Just needs to be structured properly to make sure that's authorized for you to do. So to recap, transferring your home into a trust is one of the smartest estate planning moves that you can make. Keeps your home out of probate, protects your family's privacy, and it doesn't affect your mortgage one bit, thanks to that federal law called Garn-St. Germain. If you want to learn more about securing your family's future through estate planning, watch our next video, Trust 101, Estate Planning with Trust. We'll see you there. I'm Mike Smith with the Estate Planning Guys.